When competing companies actually coordinate prices, customers, or territories, they form a cartel. As a result, customers no longer have a choice and free competition is restricted. The same applies when a company has market dominance and can therefore dictate prices. Therefore, there are antitrust laws almost everywhere in the world. However, it can make sense for competing companies to work together in specific areas. Car manufacturers could jointly develop a standard for charging stations for electric cars. Insurance companies could cooperate in the area of statistics and jointly conduct studies that benefit the insured. So, when does cooperating or sharing information become anti-competitive? As with many legal issues, the answer is, it depends. Antitrust law distinguishes between three basic forms. We talk about horizontal restrictions of competition when two companies are at the same market level. For example, two car manufacturers or two primary insurers. Classic antitrust violations could include not only price fixing, market or customer distribution, but also sharing future strategies. In clear-cut cases such as these, it does not matter how much market share the companies have in common, because these are what are known as hardcore agreements. In less clear cases, companies must have more than 10% market share together in order for any agreements to become relevant under antitrust law. However, companies at different market levels could also collude, for example, a reinsurer and a primary insurer, or a primary insurer with brokers. In this case, we talk about vertical restrictions of competition. Additionally, it is irrelevant for antitrust law whether the companies conclude written contracts or only make oral gentlemen's agreements. Even when two competitors behave in the same way in the market, for example, if they constantly offer the same prices, the antitrust authorities assume collusion, and the companies have to prove that this is not the case. The third form of antitrust violations is the abuse of a dominant market position. As a rule, companies with a market share of more than 40% are regarded as dominant. If they demand unreasonably high prices, or if they want to push competitors out of the market with competitive prices or treat comparable customers differently, this constitutes a violation of antitrust law, and the penalties can be quite large. Antitrust violations can result in personal fines of up to 1 million euros, and companies can face fines of up to 10% of their consolidated annual sales. What does that mean for each and every one of us? Make sure that, above all, you do not share competitive information with competitors, including upstream or downstream business partners that can allow conclusions to be drawn about current or future market behavior. If in doubt, contact our compliance department. We are counting on you.